Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update of the latest developments at the court and the opportunity to ask questions. In the trial against Hashim Thaçi and his co-accused, the Court of Appeals panel on 20th May decided on the appeals by Mr. Thaçi and Mr. Veseli against the pretrial judge's decision on motions challenging the legality of the Specialist Chambers and Specialist Prosecutor's Office and alleging violations of certain constitutional rights of the accused. The appeals panel denied the appeal and confirmed the pretrial judge's finding that there was no error in relation to the temporal mandate of the Specialist Chambers and that no violation of the accused's constitutional rights had occurred. In the same case, the pretrial judge, in a status conference held on 20th May, issued a number of oral orders. He set a deadline of 30th June 2022 for the Specialist Prosecutor's Office to complete the disclosure of any potentially exculpatory material obtained after January 2022 and to file any requests for protective measures as appropriate. The pretrial judge further set 30th September 2022 as the deadline for the SPO to complete the disclosure process in regards to defense requests for material and evidence in the SPO's possession that the SPO does not intend to rely on in trial. The pretrial judge also ordered the defense to file their pretrial briefs, should they wish to do so, by Friday, 21st October 2022. On 25th May 2022, the pretrial judge issued the third decision on victims' participation in this case. 12 new applicants were admitted to the proceedings as participating victims. They will be included in the existing group of 20 participating victims and will be represented by the same victims' counsel. In the same case, public redacted versions of the pretrial judge's most recent decisions reviewing the detention of Jakub Krasniqi and Recep Selimi were made public yesterday. Both decisions, issued on 13th May, ordered the continued detention of the accused, citing the risk that they would obstruct the progress of proceedings or commit further offenses. The judges also found that it is only through the communication monitoring framework applicable at the Specialist Chambers detention facilities that these risks could be mitigated. On 20th May, Trial Panel 1 ordered the continued detention of Mr. Salih Mustafa. The panel saw a continued risk that the accused will obstruct the progress of proceedings if released, due to his intelligence background, the contacts he has, and in view of a general climate of witness intimidation. The public redacted version of all three recent decisions on detentions can be found on the KSC website. In the case versus Sisni Gutsati and Nasim Haradinaj, President Ekaterina Trandafilova on 24th May assigned a Court of Appeals panel to deal with a request by the Haradinaj defense for clarification of the timeline for filing an appeal against the judgment. The defense had asked for the deadline to file an appeal to be 30 days after the Albanian translation of the judgment was available, rather than 30 days after the judgment was pronounced, as it is provided in Rule 176(2) of the Rules of Procedure and Evidence. The appeals panel, composed of the judges Michel Picard, Kai Ambos, and Nina Jurgensen, rendered its decision on 25th May. In its decision, the panel recognized the importance of the accused's right to receive the trial judgment in a language he understands, but considered that the fairness of the proceedings at this stage will not be negatively impacted by the unavailability of such translation. Thus, the panel found that the parties shall file their notices of appeal, if any, within the time limit prescribed by Rule 176(2) of the rules, namely by Friday, 17th June 2022. That is all from me, if there are any questions, I'll be happy to respond.